The U.S. Supreme Court rejects appeal over patent validity in a U.S. Postal Service case.
This is Dr. David Shine, and welcome to Business Law 101.
Suppose your company has a patent dispute with a government agency. Well, that is what happened in this case. SCOTUS declined to review a decision that invalidated a patent held by Return Mail Incorporated at the request of the U.S. Postal Service, USPS. The company Return Mail, that's the name of the company, sued the USPS in 2011 in the U.S. Court of Federal Claims. It accused the agency of violating its patent rights and technology for processing undelivered mail to be returned to senders. I'm fascinated by this concept since my mailbox is flooded with junk bulk mail, and I've started to reject it to make them stop sending me this garbage. In any event, after rather striking delay, the reports are that the Federal Claims Court ruled in 2022, 11 years later, that the patent was invalid because it just related to automating something that was presently done manually. So it did not meet the critical standard of novelty, usefulness, and non-obviousness required to obtain a patent. The U.S. Court of Appeals for the Federal Circuit then upheld the Claims Court decision in February. Return Mail then asked the Supreme Court in July to reconsider the case, and as noted, SCOTUS has just taken a pass. The issue is one that is coming up more and more in the patent life. When is something eligible to be patented? Humans are able to discover things in nature, for example, that were not previously discovered, but are simply discoveries, not actual inventions. The challenge is referred to as abstract ideas. A 2014 SCOTUS ruling established a two-part eligibility test. A court must determine if an invention involves an unpatentable abstract idea, natural phenomenon, or law of nature. If so, is there an actual invention related to this discovery? So unfortunately, this patent path is muddied up, and the current rulings are more like playing craps than a predictable process towards generally expensive to obtain patents. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.